name is Dayen. I'm the executive editor of the American Prospect. Welcome to the fourth and final webinar in a series that's been hosted by the Allowance to Counter Crime Online, American Affairs, and the American Prospect. So this webinar series is examining flaws in how courts have interpreted Section 230 and consider suggestions for fixing it. Previous panels featured discussions about the origins of Section 230, testimonies from ordinary Americans who were harmed by platforms' failure to curb unlawful activity on their services, and technical proposals for addressing illicit activity on surface web platforms. Today, we're going to be hearing from two leading thinkers on reforming Section 230. Let me just tell you about how this will work. We'll hear from each of the speakers for a short presentation and then have some Q&A. And we'd like you to get involved too. You can you send messages via chat if you're in the Zoom presentation, or if you're watching via live stream on YouTube, you can tweet at us questions to @counteringcrime, and I will receive them and we'll go forward. So we want to get started before we get to our two panelists. To open the webinar, we're really delighted to welcome two members of Congress who've been focused on these issues. First, we're going to hear from Representative Jan Schakowsky, who is the chair of the House Energy and Commerce Subcommittee on Consumer Safety. And I've actually spoken with her at previous webinars about Section 230. So this is a reunion of sorts. And Representative Schakowsky, we'd love to hear from you. So take it away.
Oh, thank you, David. I really appreciate being with all of you today. Advances in technology have fundamentally changed our society, that's for sure. And much of it has been for the good. But it is also true that our country, our democracy, even our understanding of what is truth have been hampered by the proliferation of disinformation, misinformation, and extremism, all of which has deeply divided our country. In March, the House Energy and Commerce Committee had a joint subcommittee hearing, including on my subcommittee, with the CEOs of Facebook, Google, and Twitter. And that hearing made it clear that the status quo is just plain unacceptable. My Democratic colleagues and I stand in unity in pursuing a tech accountability agenda, For too long, technology companies have allowed harmful content to spread throughout their platforms and to violate their own promises to consumers. Worse, they have used Section 230 of the Communications and Decency Act, which you all know, to shield themselves from liability. So self-regulation of these technology companies has come to the end of its road. And that is why I introduced the Online Consumer Protection Act with my colleague, Representative Castor from Florida. This bill will protect consumers by ensuring that online platforms have to have clear, transparent terms of service, and that they enforce those terms of service. It also directs the Federal Trade Commission to study establishing something on the order of nutrition labeling for terms of service and for privacy policies. We must make it easy for consumers to understand what they are agreeing to and to hold those companies accountable when they fail to live up to their part of the bargain. So Facebook failed to live up to its promise in the months leading up to January 6th, despite excuse me, I'm sorry. Okay, despite banning stop the steal content, their platform was actually used to plan and execute the insurrection. And if my bill were actually part of the law, the family of Officer Brian Sicknick, who, as we know, died as a result of the Capitol riot, he could have sued Facebook and made them accountable for its broken promises. And the Federal Trade Commission would have likely been pursuing a case against Facebook for its negligence. And I imagine that actually state AGs might have filed suits as well. And that is the key thing about the bill that I introduced. It's all about accountability. And we need layers of accountability. What finally got big tobacco under control were three things. The triple threat of the federal enforcement, of state enforcement, and class action lawsuits. It is past time for the technology industry to be held accountable for their failures, and consumers just can't wait any longer. And we can't allow the damage that is happening to our consumers as members of Congress and as advocacy groups. Section 230 reform, including but not limited to my legislation, the Online Consumer Protection Act, is key. But we can't stop there. We have to have privacy and antitrust legislation is essential. There are essential components of a strong tech accountability agenda. And I really look forward to working not only with my colleagues in Congress, but also the reform activists like are here today and advocacy groups in the coming months. And I appreciate all the work that you have been doing in raising the problems with 230. So we're going to work on all fronts, but especially on reforming Section 230. We cannot move quickly enough to hold these tech companies, these giant companies, bigger than countries in many cases, accountable, and to protect Americans online. So I just want to thank you once again for allowing me to be here, and I hope you have, I know you will have, with the panelists that you have a wonderful panel. So just thanks so much.
Me unmute. Thank you so much, Representative Schakowsky. Appreciate it. Now we're going to hear from Representative Bob Latta, who is the ranking Republican on the House Energy and Commerce Subcommittee on Communications and Technology. So let's hear from him. Oh, here we go.
I'm Bob Latta, and I serve as Republican leader of the Subcommittee on Communications and Technology on the House Energy and Commerce Committee. I am pleased to help kick off this panel today to discuss how we can hold big tech accountable and protect free speech. Over the past few years, we have seen more and more examples of big tech taking advantage of the liability protections provided to them under Section 230. Conservative voices have been squashed, illegal drug sales have thrived, and children have become victims of suicide, addiction, and trafficking. Big tech cannot keep engaging in discriminatory practices and hosting harmful and illegal content on their platforms. Republicans on the Energy and Commerce Committee are working to hold big tech accountable. Republican leader Cathy McMorris Rodgers released a big tech accountability platform to open the discussion on this important topic. As the Republican platform outlines, we need to increase transparency, enhance oversight, require consistent moderation practices, decisions, and improve competition. We know that we must take a thoughtful, balanced approach to modernizing Section 230 because there is a good intent behind the law. It serves a purpose and has helped the internet grow into what it has become today. That is why we want to talk about reforming the law in a way that continues to foster innovation online without suppressing free speech or allowing illegal activity to flourish. Let me be clear, we want to increase oversight over big tech, but we must do so carefully and strategically to avoid unintentional consequences. It is time for big tech to be held accountable, children to be safer online, and for all Americans to be able to exercise their constitutional right of free speech without being censored. Thank you for allowing me to be part of this discussion today. I look forward to working with all of you as my subcommittee explores options aimed at holding big tech accountable.
All right, thank you, Representative Latta. So now we'll head on to our main discussion. As Representative Latta mentioned, Section 230, there's no doubt that it has played a critical role in the structure of the internet. Sometimes it's called the 26 words that created the internet. But now, these days, it's facing calls for amendment to address the facts that online platforms just don't have legal incentive to curb illicit and toxic content. Indeed, it has plenty of incentive to use the shield of 230 to protect itself when illicit and toxic content is created and produced on its own websites. And individuals have essentially no recourse in court when these issues take place. So today we're joined by two leading legal analysts on Section 230. We have Professor Danielle Citron and Neil Fried, who are going to discuss the problems that have arisen as a result of various interpretations, judicial interpretations of Section 230, and proposals for revision. So this discussion is particularly pertinent given that lawmakers have put forward so many proposals. Indeed, we just heard from two of them to revise Section 230. And recent court rulings indicate that the precedent is on the verge of changing. So there's a lot of dynamism around Section 230, a lot of things happening. And so this is a great time to have this discussion. So our first speaker is Professor Danielle Citron. Professor Citron teaches law at the University of Virginia, where she is focused on privacy, free expression, and civil rights. In 2019, she was named a MacArthur Fellow based on her work on cyberstalking and intimate privacy. In 2018, she received the University of Maryland Champion of Excellence Award. And in 2015, the United Kingdom's Prospect magazine, which is different from the American Prospect, named her one of the top 50 world thinkers. The Daily Record also named her one of the top 50 most influential Marylanders. She published a book, Hate Crimes in Cyberspace, in 2014, and has published more than 40 law review articles. She has testified multiple times about national security and privacy risks of deep fakes and has been deeply involved in reform efforts around the regulation of online platforms. She is currently working with the Senate and House staff on proposed Section 230 amendments and has been working with major tech companies on privacy matters. And so I welcome Professor Citron to the discussion, and let's hear from you.
Gosh, one will never get used to this, having to unzoom oneself in this Zoom era, which we hope is ending fairly soon. Though Zoom is wonderful for bringing us all together, and so appreciate the invitation and so happy to be here. So thank you everyone for making all of this happen. It's really the first time I called for reform for Section 230 was in 2008 in an article called Cyber Civil Rights. And I urged that platforms should have a duty of care, of reasonableness. And at the time, it was a radical idea. My colleagues in privacy and free speech said that I was breaking the internet, that I was killing free speech online. And one even said I was trying to jail communists, which I understood the idea, right? The concern about free speech. And what is fascinating is here we are in 2021, and the very idea that we should reform Section 230 isn't insane anymore, right? It's not off the wall. It's in fact on the wall. So we've really seen the window shift. But just to go back 25 years to 1996, what motivated Congress in amending, or as part of the Telecommunications Act, we had the Communications Decency Act. So let's just take a moment and emphasize that. It was basically an anti-porn law. But part of there is an amendment, Section 230, whose purpose was to incentivize self-monitoring. And in part, it was a response to a trial court decision in New York, which found that if you, Prodigy, if an online service provider tried to clean up the internet, then they were going to be held responsible as if they were newspapers, if they were publishers, and therefore strictly liable for trying but failing, so under filtering, defamation, which as was the case. And so you had a representative, a conservative and a liberal, folks working across the aisle, Chris Cox, Ron Wyden, and they wanted to ensure that platforms that they helped, certainly federal agencies couldn't do all the work cleaning up the internet, and they wanted platforms to help them monitor themselves. And so they devised two pieces of Section 230. One has to do with the underfiltering of content. The other is the overfiltering of content, if you do it in good faith. And the provision I'm going to focus on, we see some disagreement about what the problem is. In my view, the problem of Section 230 is the provision that permits or that provides a legal shield when you do too little, right? When you underfilter content. Because what we've seen, so the language itself unfortunately does not condition the immunity on any responsible or reasonable behavior, even though the subtitle of the statute is Good Samaritan, I'm quoting, Good Samaritan blocking and filtering of offensive content. But the language doesn't specifically condition it on being a good Samaritan, and I wish it had, though it was its purpose. And so how courts have interpreted is an overbroad way. And so in my work, I'm the vice president of the Cyber Civil Rights Initiative, and I've been working on issues involving cyber stalking and invasions of intimate privacy since 2007. And what we've seen are sites that specialize in online abuse, sites that make money off of the posting of nude photos without consent. They're immune from responsibility, even though they directly solicit, facilitate, essentially cyber stalking and invasions of intimate privacy and make money off of it, right? Sites that know about abuse and persistently ignore reports, do nothing about it, they too are immune from responsibility, as are sites that frankly have nothing to do with speech at all, right? The idea of the overbroad interpretation of 230 is because courts, federal and state courts, are finding that, look, one of the purposes of 230 is to enhance the diversity of speech online. And so the overbroad interpretation of Section 230 is in the name of free speech, right? But what's interesting is that and disappointing is that the provision has applied to even sites that basically are in the business of selling guns, right? They just get a share of the profits, has nothing to do with speech, but nonetheless, Section 230C1 has immunized them from responsibility. And it's costly. Right. The immunity has meant that victims of cyber stalking and non-consensual pornography, among others, really, they don't have a deep pocket to go to. Right. There are perpetrators. You can try to sue them if you can find them, but suing them just isn't a real possibility as a practical matter because there's just no money. Right. And so what we have is basically bad Samaritans, the opposite of what Congress wanted, enjoying immunity from responsibility under Section 230. And so I have in a sort of my work has evolved over the years. So in 2009, I called for a reasonable duty of care and then got screamed at by my community in my book, Hate Crimes in Cyberspace. I basically had offered a carve out to Section 230, which was bad Samaritans, essentially. If you primarily focused on and engaged in and hosted illegal activity, then you couldn't enjoy the immunity. And finally, I got brave enough to go back to my original idea. Ben Wittes and I wrote a piece that I can give the specific statutory language for you, but to amend Section 230. So it would say, so no provider or user of an interactive service, and now I'm going to add some language, that engages in reasonable content moderation practices in the face of clear illegality that causes significant harm, shall not be treated as a publisher or speaker of somebody else's speech effectively. And so what it would do, the reason why reasonableness, so often I'm asked, isn't that a vague standard? Law loves reasonableness, right? There are bodies of law built on the notion of reasonableness. I've worked with companies for 12 years on content safety, on their safety practices. And so reasonableness is not a new idea in this content moderation space. We've been working on these issues for 12 years behind the scenes. And so I've been working with folks on the House and the Senate side. We've made some missteps, unfortunately. I worked with Senator, when she was then Senator Harris, on FOSTA and SESTA, which turned out to be a disaster, frankly, and I'm happy to talk about why. But I'd like to see us bring us back to the original purpose of Section 230, right, which was incentivizing the Good Samaritan. So I'll leave it there.
Great. Thank you very much, Professor Citron. Very interesting. So let's go to our second speaker, and that's Neil Fried. He launched Digital Frontiers Advocacy in January 2020, bringing more than 25 years of experience in the public and private sectors. Before that, he spent 7 years as Senior Vice President for Congressional and Regulatory Affairs at the Motion Picture Association of America, where he worked on behalf of Walt Disney Studios, 20th Century Fox, or what was 20th Century Fox, Netflix, Paramount, Sony, Universal, and Warner Brothers. Previously, he was a legislative aide to the House Energy and Commerce Committee, where he served as chief counsel on media and technology issues. He advised the committee for nearly a decade on television, radio, wired and wireless communications, spectrum, cybersecurity, public safety, broadband, and internet issues. He helped draft and usher into passage the Digital Television Transition and Public Safety Act of 2005, Satellite Television Reauthorization Acts of 2004 and 2010, and the Spectrum Incentive Auction provisions of the Middle Class Tax Relief and Job Creation Act of 2012. So I want to welcome Neil Fried here, and let's hear from you.
Thank you, David. Professor Citron is, of course, a very hard act to follow, and I just want to make clear that I wholeheartedly agree with her that the real problem is we haven't conditioned the safety, the immunity of Section 230 on actually taking reasonable steps. Because as she points out, the whole point of Section 230 following Stratton Oakmont was to shield platforms when they do the right thing, not to give them immunity when they do the wrong thing. And the problem is that the overbroad application, as again she points out, has actually diminished their incentives, their legal incentives to moderate and exacerbated, and in fact, in some cases, facilitated a whole host of harms. Because, but for Section 230, platforms, like any other business, would have a duty of reasonable care. They would have to take reasonable steps under the common law. All businesses, and not just business individuals, have a duty to act reasonably to prevent harm. And but for Section 230, that would apply to platforms. But because of overbroad interpretations of 230, courts have essentially said that the duty of care does not apply. And that means that when platforms negligently, recklessly, or even knowingly facilitate illegal activity, they cannot be held culpable. And what's important is finally courts are actually saying that this has gone too far. And I just want to quote from an important case out of the Ninth Circuit, where the Ninth Circuit just said that, and I'm quoting, "There is no question Section 230C1 shelters more activity than Congress envisioned." This is a trend. The Ninth Circuit has had a couple of recent decisions. The one before that last month was Lemon v. Snap, where the court said that defective design of your platform is not shielded by Section 230. In the Gonzalez case I just quoted from, the court said that making money through illegal activities by sharing revenue is not protected by Section 230. We have the Texas decision just recently that said that sex trafficking allegations could go forward because in light of the recent amendments, Section 230 does not prevent those sorts of claims. It did say that common law claims could not move forward, and we'll get back to that in a minute, but it said that statutory claims in Texas over sex trafficking about benefiting from sex trafficking could go forward. Does not mean the case is over. The case still needs to be proven. But the good news is that the victims will get their day in court. And notably, there was just a case actually also in the Ninth Circuit that was largely dismissed over allegations of racial bias. But the court said that the plaintiffs could refile their complaint to demonstrate that there was actually amplification of racist speech on the platform. Again, doesn't mean they're going to win the case, but the good news is that we're starting to get decisions that say 230 is not a bar to seeking justice by victims when platforms don't do the right thing, right? Again, we're going to continue to protect them when they do the right thing. They should be shielded. They shouldn't be punished like Prodigy for trying to do the right thing. But if they've acted negligently, recklessly, or knowingly in facilitating illegal activity, the case should proceed and should go to the merits. And that's really the goal here. So the good news is the courts are moving in that direction, but here's the problem. And this is why the courts are not only taking a more narrow interpretation of Section 230, but they're also still calling for Congress to change the law. And that's because they all lament that even though they have this more appropriate interpretation of Section 230 that separates the conduct of the platform that's itself facilitating legal activity, not covered, separating that from when they do take appropriate steps, reasonable steps, is shielded, there's still a middle category, which is that if the defect in the service, if the conduct of the platform is still inextricably intertwined with the publishing role, the plaintiffs still can't go forward. And so this takes us back to, again, Lemon v. Snap said, good news, that case about a speed filter had nothing to do with the publication. The court said that by creating a speed filter that encouraged people to speed excessively while they take photos, and unfortunately led to some deaths, that conduct was the negligent creation of the filter, had nothing to do with the actual uploading of the photos. Again, the court hasn't said that that case is over, but it can proceed. But here's the problem. The court was very clear to say, but if it's not separate from the publication role, even if there's a defect in the service, if that defect in the service is about the publication, 230 still applies. And so unfortunately, the best example perhaps is the Herrick case, where a user of a dating app was being essentially harassed by an ex who was pretending to be him and sending people to his door to do unspeakable things. And while you can certainly claim that there was a defect in the way that that service was designed because it was allowing impersonation and the platform wasn't preventing it, I fear that even in those sorts of cases, because it's still about the publication of content, even these new readings will not prevent Section 230 from preventing cases to proceed. So I still very much agree with Professor Citron. We need to amend Section 230 to make sure that if you're not acting reasonably as a platform, even in the moderation of speech, the cases should proceed. Now, again, this is not going to break the internet, right? Because again, if they act reasonably, a very well-documented standard, as Professor Citron points out, they still get the benefits of 230. We still have the reason for passing 230, which is just going back to Stratton Oakmont, when Prodigy did the right thing, and if any other platform did the right thing, even under the amendments we're all talking about, they would still get to use Section 230. Expression on the internet would not come to an end. The First Amendment would still apply. Cases would still be dismissed. If you look at even the Internet Association's own data, many of the cases, more than half of the cases that are brought under Section 230 are not resolved under Section 230. Bad claims are still dismissed for being bad claims, regardless of whether 230 is there. So bad claims will still be dismissed. And again, right, the Gonzalez terrorism case, the Texas case on sex trafficking still need to be addressed on the merits. If they've made their case, they'll win. If they haven't, they'll lose. The platforms are still protected from faulty claims. Interestingly, after what we just saw with the decisions about the FTC and the states moving forward on antitrust issues, fixing Section 230 itself will have some competition benefits, because the problem is that because platforms have this shield that no other business has, in fact, many businesses that they compete with directly that are brick and mortar, they have an advantage, right? They don't have to put the time and money into protecting their users like every other business does. That lets them grow faster, lets them operate a little more recklessly, lets them divert resources away from protecting their users and towards further growth. If we fix Section 230, we will address some of those anti-competition problems. And again, there are reasons perhaps to discuss regulation along the lines of privacy or other areas. This is not regulation. Everyone loves to say we're going to be regulating the internet. There are certainly proposals to do that, but this doesn't do that. All this proposal would do is say, innovate all you want, experiment all you want. You have all the discretion over your business model on the front end. But if you act like any other business, negligently, recklessly, or knowingly in a way that harms people, like all those other unregulated businesses, including the platforms, these unregulated businesses can still be brought before a court if they've harmed someone. And while that is an after the fact remedy, that liability risk encourages the platforms to act more responsibly upfront and hopefully minimize the problem in the first place. That was the whole point of Section 230, to encourage the platforms to moderate. So again, we've made some great strides in the courts recently. I still think we need legislation. Thank you.
Okay, thank you very much. We're now going to go to discussion, and as I mentioned before, you can use the function within Zoom to the Q&A function, or if you're following along on YouTube, you can send a tweet at Countering Crime, and we'll get that question. So I have a bunch of questions in the queue. I want to start with my own, because anytime you have a panel where the panelists agree, it is said you have a boring panel. So it is up to me to be the non-boring part of this panel and ask some question that will get at some differing responses maybe. I see the point on a reasonableness standard, a duty of care standard. I guess my question is, I think that makes a lot of sense for sites that are purely based on abuse, as Professor Citron said. But with the larger platforms, it seems to me that the enormity of the task that they have for moderation and for rooting out illicit content is in itself a reasonableness problem. Like, what happens when the platform itself is somewhat unreasonable and the nature of the task being asked of them is unreasonable? Does that argue for some competition limits, as Neil alluded to? How do you deal with companies that are seemingly impossible to moderate? And I'll do a follow-up later about just and Neil alluded to this, like the use of 230 as a weapon, as a shield, as an ability to gain a competitive advantage. So either of you can take that.
So why don't I just clarify, because I'd love to hear Neil's thoughts on competition, which is really out of my zone of expertise. So I just want to clarify what my proposal is, which is what courts would do on a motion to dismiss, which is early on in a case, is assess whether the company, the platform, has engaged in reasonable content moderation practices with regard to a specific kind of illegality writ large. So it's not the question of what has the platform done vis-a-vis a particular piece of content, right, or behavior. Mm-hmm. No, that's not the question, right? Mm-hmm. The question is writ large with regard to the illegality as alleged in the lawsuit, right? what has the platform done in terms of its content moderation practices? And so your point, David, was, look, these platforms are very large, right? They can have up to billions of users. If we think about Facebook, right, and millions, if there are others, they're not bad Samaritans inherently speaking. In fact, you might, in some respects, say that they are truly emblematic of good Samaritans, having been working with a number of platforms not for compensation, but for 12 years. I can say that, the first to the table on non-consensual pornography was Facebook, right? It made sense for their business model. It's not because they're nice, right? They ban nudity. And so they've innovated. So Hani Farid and I have been working with them, and they've innovated to prevent and to filter before photos are uploaded, photos that have not appeared online, but that victims send to Facebook. They've innovated because it's been in their interest, right? Mm-hmm. And so the reason why reasonableness is a place I land, right, is it looks at the practices vis-a-vis particular kinds of illegality that they would be, as Neil underscored, responsible for if they were offline, right? If they were brick and mortar. We look at their content moderation practices in face of that illegality. That's not that ask is one that they would if they were offline, right? They'd have to deal with some forms of responsibility. It's not strict liability. It wouldn't mean because you host threats, if you have no approaches to threats, right? True threats, right? It would mean that you're not acting reasonably, right? You have you don't have policies, you don't have practices, right? That would be a problem, right? In the Herrick case, we talked about the Grindr versus Herrick case. Grindr had no way to block IP addresses from an imposter who was invading intimate privacy. That is, its design was defective, right? Its design, even though it could know with great surety that people would use it to share nude photos without permission, to stalk, harass, it designed the site so that it couldn't block, which seems rudimentary and ridiculous, right? Couldn't block IP addresses and ignored his 100 complaints, right? That's not reasonable. And so I don't think it's a good point about in an ever-changing world, what's reasonable one day is going to be different from what's reasonable in the next. And that's actually, I think, an advantage of the proposal, which is it incentivizes companies to innovate, to not rest on their laurels, right? And do just as Facebook did because it was in their interest, right? To innovate and not have a checklist that becomes stale in 5 minutes. But I can tell you that there are minimum standards that I would say we can come up with and we can glean from trust and safety work that we've done for 12 years, that there's some bare minimum standards for what's reasonable. But then what reasonableness would do is, much as we see in the cybersecurity field, you got to keep up with best practices. It's a moving target, and I want it to be.
Great, thank you. Neil, I want to take this to you, but I want to maybe sharpen my point. You say, Danielle said it's in the interest of a business to have this reasonable standard, and it's in the interest to not host harmful content that would harm their users. What if it's in the interest of the business to use Section 230 to take away some of the burdens that are upon themselves? I'm reminded of Amazon and the way that it gives counterfeits or defective products as a problem for the third-party seller rather than a problem for Amazon itself. And that's because it's simply more cost-effective to Amazon and their bottom line to throw that upon the third party rather than to say that we're, a publisher of manufacturing content. So
right. We're not treating them as a publisher or speaker. 230 should never be on the table. Neil, I'm going to let you sort of address this, but the very notion that getting a cut of a sale is treating an entity as a publisher or speaker shows you how off the rails 230 has gone. Okay, Neil, now I'll try
exactly. Neil, could you just weigh in on that?
Yeah, I mean, this touches the competition point as well as just that the law is actually encouraging essentially not recklessness, but less resources spent on planning. right? So any other business would have to take these issues into concern. Wouldn't be able to simply say, I'm going to make that a third-party problem. At some point, any storefront has to act reasonably about what it distributes and can't just push all the liability off on the people that have made the product, at least when they're involved in the facilitation of that transaction. So this solves that competition problem. The small guy can't just sort of be the stooge here. Everybody has to do their part to make sure that the transactions are done in a reasonable manner. But the second is, one reason why these platforms have gotten so big, one reason why, Grindr may have developed with no solution for the imposter problem is they didn't have to. They have grown faster, they have grown larger because they didn't have to think about these things. Every other business may take a second moment, may wait a step and think through what are the problems that we're not anticipating? What more do we need to do before we roll out this new service, before we roll out this new feature in our brick and mortar business? The platforms ordinarily would have to do the same thing. And maybe they would grow a little slower, but they grow a little safer. And I don't think the trade-off is large, right? The benefit to public safety outweighs whatever the small extra heartbeat they have to take to think through what they're putting into practice, right? The move fast and break things, right? The cliche was the problem. And maybe they'll move a little slower, but they'll move a little safer, and we'll still get all the benefits of the technology without some of the downside.
Move fast and break things being the problem. That's a perfect way of articulating that. So I'm going to go to some of the questions from our audience. One of them referred to something that Professor Citron said in her opening remarks. So Tina Page asks, can SESTA and FOSTA be used to hold platforms accountable? And you describe SESTA and FOSTA as a disaster, and that's a direct quote. So I'm curious if you would elaborate on that and why that reform or chipping away at 230 didn't work.
So I'm not a huge fan of carve-outs, right, in a piecemeal manner, but that's not why it troubles me. What it does is it says that if you knowingly facilitate sex trafficking, then you're sort of off the hook for it. Then you might be responsible under the federal online sex trafficking laws, right? And so the problem with a knowing standard, like knowingly facilitating, would lead to the moderator's dilemma, which is why we have Section 230, right? Which is, if you know, just like Remember Prodigy knew and tried to get rid of dirty words and then did an incomplete job, and the lower court found that it was acting like an editor or publisher, right? If a platform knows, right, or should know, or knows that there is sex trafficking content, then they're on the hook. Best thing for them to do is to hide their head in the sand, right? So what we've seen in response to SESTA was two things: over and under removal to the extremes, right? Sites either took everything that had to do with sexual expression off a site, right? So they couldn't be understood as knowingly facilitating sex trafficking, or they essentially took out of their terms of service anything having to do with sexual expression at all, let alone sex trafficking, right? So it leads to here we are again, the pathologies that gave us a problem that Cox and Wyden wanted to solve, which is to incentivize filtering, blocking, removing, in good faith, illegality. It brought us back to the same problem we were trying to solve. And so when I worked on it on behalf of Senator Harris's office, we raised the questions with folks, but it's passed, and it passed overwhelmingly. And so I think nearly everybody signed on to it, So Gretchen has noted, so Peters, who is part of the supporters of this panel, has noted that we haven't really seen cases brought under FOSTA and SESTA that have been effective. And to the extent that we've seen it, the Texas Supreme Court sort of got it wrong. And so, I don't think it's a big win for us. If we're going to do a carve out, I'd like to see us carve out civil rights laws. But in any event, I'm owning the fact that I think having worked on advising Senate side on FOSTA SESTA, I thought it was a wrong move, and it sort of gave fire to those who say, oh, you reformers, you just want to squelch speech. And unfortunately, it didn't do very much to help us. And if it's okay, whenever we finish, David, if I have a question for Neil at some point. So
let me take this one first.
Okay, of course.
David said he would like a little difference of opinion, so I'm going to give him a different opinion. I don't think we can say that SESTA FOSTA has been a failure. In fact, the fact that we haven't seen a million cases shows that we haven't had the internet break, right? The sky has not fallen, right? And the Texas case doesn't say game over, platforms lose. It simply says the victims can go forward and try and make their case, right? And if they have a good case, they should win. If they don't, the platforms will win, right? All we're saying is that Section 230 shouldn't bar a victim from bringing their claim. Again, and the case here, remember, the statute that Texas said they could bring their claim on was whether the platform was benefiting from, profiting from, improving its business from sex trafficking. It's the same issue as in the Gonzalez case. It's the same issue as in the Herrick case. The question is, are the platforms actually benefiting by facilitating sex trafficking? That's an important question to ask. Again, if you can't prove it, the platform wins. But we haven't seen the sky fall. We're just starting to see some cases come forward. We have seen that the sex trafficking sites are moving out of the United States. That's a good thing. We don't want them here. I think it's important to make sure we don't now export Section 230 and now make the problem that the other countries can't solve it, right? Put all our problems on them. That's not the right result. But I don't think we can say that SESTA FOSTA has been a failure. I think it's important to let victims bring their cases.
Well, we have a ton of other questions in here, so I'm just going to pop in and grab one, and then Danielle, maybe we'll get to your question. So here's a question from Claudia Rizzi. Can the primary business of social media platforms still be considered publishing as opposed to advertising? Are these truly advertising companies when you come down to it? And if they were redefined as advertising companies like Google or Facebook, would they still be shielded under Section 230? It's an interesting question. I'll leave it to either of you.
So I was going to say that it's an interesting question. It was raised now by the Gonzalez case, which said that 230 would not block a claim that platforms were essentially sharing revenue for terrorist propaganda. Again, in that case, even further, they still said even though 230 doesn't apply, the case wouldn't proceed. But the question there was that the valuable discussion there was that 230 doesn't apply to revenue sharing, right? Now, there's going to be a question here. What is the role? Are you acting as a publisher when you pay the entity that's publishing? Maybe, but that's not what was happening here, right? ISIS was getting paid not for the content it created. ISIS was getting paid when someone else put an ad on the propaganda, on the terrorist propaganda. And what the court said was sharing money, essentially paying money to ISIS, is not the role of a publisher. Doesn't mean that the case would proceed. And in fact, the court, after saying 230 didn't apply, then dismissed the claim. But the important point there is we've got to separate the role of a publisher from other activity of the platform. Did the platform encourage illegal activity? Did it fund illegal activity? Did it incentivize illegal activity? Those are not Section 230 questions because they're not publisher questions. So I think that's an important question. There's going to be some line drawing that has to happen, which is again why I think the courts are frustrated. They would like to see Congress step in with legislation to make clear what it is that we want to protect platforms from liability for, and what do we want to keep the same duty of care. If you're acting negligently, recklessly, or knowingly in facilitation of illegal activity, that's not a 230 question.
But to be clear, just because I don't want Congress to think they're off the hook, most courts have not interpreted the language publish or speaker narrowly, right? They have very broadly interpreted. So of course, advertising is is publishing, right? That's quite literally, go look at our, the newspapers we used to have and read, right? We're filled with advertising. And so on the main, in most circuits and most state courts, we see a really overbroad interpretation of publisher and speaker. And just one thing to say that, in fact, we are seeing, there are sites who specialize in illegality, and in particular, non-consensual pornography. They haven't left the country, Neil. And so when I started working on these issues, there were like 300 sites in 2008. There are now over 9,500 whose business model, advertising business model, are hidden cams, non-consensual pornography, deepfake sex videos. And so they're not going anywhere. In fact, when they're closed down, let's say, for example, a very popular non-consensual porn site was closed down in Denmark. Where did it set up shop? Las Vegas, right? It's now hosted in Vegas. And so we are the scofflaw, and we export that scofflaw status to the rest of the world because it can be hosted here with no risk of liability.
Well, hopefully the Texas case will wake those platforms up.
I might go hold my breath. I want to see the law reformed. I guess that's why we're doing this.
Right. Right, exactly. Danielle, you mentioned that you had another question here for Neil. If you want to bring that out at this point.
Only because it's fun to have Neil here, because I'm always asked a particular question, and it's great to have someone who's an antitrust and a free speech scholar sort of in the conversation. So I'm always asked, Neil, how is it that your proposal essentially is going to help the Facebooks, the established players? They have reasonable content moderation practices. You've helped them with them. In fact, your proposal entrenches them further. There'll be even bigger monopolies. And it's the little guy your proposal harms because they don't have the apparatus of content moderation. They don't have the thousands of employees, and you've been not working with them for years, right? And so my response is that I think if you're going to try to get into the space, that you've got to be responsible for illegality, especially not only if you specialize in it, but it's like plutonium. Right? You don't just go in the business of gathering plutonium. So we need to have a set of preconditions. But Neil, what do you make of that comment, right? That I'm feeding the beast to Facebook. I'm put up to it by Facebook, which is frankly absurd because they pay me nothing and I get to criticize them. But does that make sense, Neil? So I'm always like, where's Neil when I need him?
So a few things. First, I have to caveat, I am not an antitrust expert.
Yeah, you know much more than I do.
So I will take the competition issue, but I am an energy and commerce alum. So I was in charge of the communications issues, not the judiciary antitrust issues. But I will address the competition point. And I'll give the answer that I think you've already given, which I think is the right one, is that the reasonableness standard is inherently flexible, right? What we expect of a small platform is completely different than what we expect of a large platform. And here's the good news. By and large, the small platform has less resources, but the small platform has fewer users. The small platform has fewer uses, right? They're not in 20 different lines of business. And so they don't have as much to do. And the court will say, you're a small entity. What did you do? Did you spend some time? Did you think about this? Do you have a process for the consumer to say, hey, there's something wrong here, please help me, right? And that may be enough. Whereas if it's Facebook and Google, who have more money than God, maybe they have a little more they have to do. And again, that makes sense because they are in so many lines of business. So you've already answered this question. The reasonableness standard is flexible. But the good news is that the small guy, right, the big guy and the small guy now each have to deal with their own burdens. Whereas, before the big guy just grew bigger and faster, because if you have the first mover advantage and don't need to worry about harming your consumers as much, right? I mean, look, they're not heartless. They want a good business. But I guarantee the lawyers will slow them down if they can be sued. So the big guys get bigger faster when they don't have liability because they've got all the resources and they pour it right back in and they throw the accelerator on.
That's great. That's always a classic kind of argument that gets made, that you can't regulate big tech because then they'll just get bigger and see what you've done. So it's a clever argument. To that end of where those responsibilities lie and maybe are greater on the part of larger platforms. We have a question, I'm not sure who gave it, but the question was, does the algorithmic amplification aspect of this blur the lines between being a host of content and being a publisher? And should that be considered? The way in which cyber stalking, for example, is facilitated by algorithms. How do you incorporate that into this reasonable standard? Does the reasonableness go at the level of the algorithm?
So that's front and center now, at least in the Ninth Circuit, because in the terrorism case, that was the claim, that it wasn't the publication of the content, it was that the platforms were actually amplifying and putting terrorist propaganda in front of more people and in front of the very people who were most susceptible to it. And what we saw now, the court said essentially that's not enough, right? The amplification is still, at least as 230 is currently drafted, 230 prevents claims about amplification. One of the justices dissented. The other two justices lamented that they couldn't let again, does not answer it, but they would have liked that claim to proceed, but couldn't. And in fact, one of the justices said that were it not for the precedent in the Ninth Circuit, she would say amplification is not blocked by Section 230. And she wishes that the Ninth Circuit would hear that issue again en banc. I don't know the answer yet, but the question is amplification, and not just amplification, but tailored amplification, the collection of information about your users to specifically put harmful content in front of them, is that publishing or is that your own action? Right now, it's clear, at least in most courts, and certainly reluctantly in the Ninth Circuit, the justices said, 230 prevents claims of amplification, but they all are having second thoughts about that and would like Congress to think about it.
We probably have time for, I don't even know. Well, I'm going to try for one more question because it's fairly provocative. So the question is from Townsend Koch, I guess. I'm not sure how to spell that, pronounce that. Isn't the push for innovation in content moderation in ever-changing times a recipe for increasingly restrictive and capricious standards regarding allowed speech as public opinion evolves on controversial political topics? So, the question of that, this being an ever-moving target, does that give publishers perhaps an easier out to say that the times are changing? I'd welcome maybe Professor Citron can address that.
Provocative, nasty, offensive speech is fully protected speech in the United States. And so, we have a robust First Amendment that is in the background of all of this. And so the reasonableness inquiry would not, for political speech, which is, if there is a hierarchy of speech interests, we think of political speech, and the court has said on a number of occasions that political speech gets the strongest protection of all speech as opposed to purely private matters. And so reasonableness wouldn't, the question wouldn't be, did you react reasonably in the face of obnoxious, loud, offensive, protected speech, right? It would be reasonableness vis-a-vis a particular form of illegality that can be regulated under the First Amendment. So I think it's less of a question than that is like it's more of a performative question than it is a real one in some sense.
Okay, very good. I wish we had more time, but we are going to need to wrap up with that. I want to thank Neil Fried and Professor Danielle Citron for joining us. Thanks to Representatives Schakowsky and Latta for their statements, and thank all of you for attending this very important discussion. There are going to be links to this event and every event in this series available on the website of the Alliance to Counter Crime Online. That's counteringcrime.org. As well as the YouTube channel, our YouTube channel as well, at the American Prospect. And on behalf of the American Prospect, American Affairs, and ACCO, we really hope this is the beginning of a national discussion on reforming how the internet is governed. So thank you very much, and have a great day.
Thank you.